Ramos de Paraguay. Damos uso de la palabra a la doctora Mergul Bobukeiva, secretaria de la Sala Constitucional de la Suprema Corte de Justicia de Kirguistán.
Good day, participants. In advance, I would like to say sorry for my English. My English is not well, and during my speech or in the session, I would like to ask my translator, Konstantin, to assist, to help me, if you will have questions on my speech. So, and according to our reglement of session, I have to make short speech, and if you want to take and values that are declared in Article 51 of the Constitution of India. Mention article of the Constitution notes that the Kyrgyz Republic seeks for universal and fair peace, mutually beneficial cooperation, and the resolution of global and regional problems by peaceful means. Thus, our constitutional values in this respect are similar. Now let me disclose the topic of the presentation. The Constitutional Chamber indirectly creates the law by exercising the function of constitutional control. In the process of application and implementation of the norms created by norm makers, it can create new rules, supplementing and specifying provision of the disputed act. Also, by means of constitutional control, through the interpretation of the norm of the Constitution, determines the direction of development of legislation, thereby developing and creating constitutional legal doctrines. As you know, especially our justice, judicial activism is understood as a legal concept of the administration of exclusively constitutional justice, and is a conceptual basis of a living constitutionalism or living constitution. Of course, this concept is different from the traditional perception of the role of the judge, given in the due time by Montesquieu, when the judge is tasked always to be just and exercise enforcers of the law. This presupposes, first of all, self-restraint of the courts, which is considered to be the norm in the court practice of the Constitutional Chamber. Constitutional justice bodies should leave the legislator the sphere for particular decision-making, and in any case does not interfere to the process of making such decision. With regard to the doctrines of judicial activism, it is largely based on the political role of judges, who must intervene when the legislator elected by the people either fails to act when necessary or enact laws that violate fundamental constitutional values. These doctrines can also be applied by the constitutional justice body when there is a gap in the legal system, specifically in legal succession of the state legal process. That is state where change of power not evolutionary, but revolutionary way. Scientists call such phenomenon as breaks in legal gradualism. In order to mention and ensure the sustainability of legal regulation, judges have to show such activism. Otherwise, the consequence of such a gap may make law enforcement more difficult for all legal entities and individuals, and lead to uncertainty. So, in the practice of the Constitutional Chamber, there is a decision where the concept of judicial activism was applied in assessing the constitutionality of the act of the provisional government in order to eliminate legal uncertainty. It should be noted that in the Kyrgyz Republic, the transition of full state power to the provisional government on April 7, 2010 was the result of socio-political events in the country. Thus, in the decision of the Constitutional Chamber of July 11, 2014, on the case of checking on the constitutionality of the decrees of provisional government, the Constitutional Chamber expressed the following positions. As a result of the events of April 2010, there was a complete inability of the government to carry out its functions. This allows us to conclude that the establishment and function of the provisional government was due to objective reasons derived from the extraordinary socio-political situation and the need to exercise state power in order to stabilize the social, political, and social economic situation in the country, to ensure public order and security. Thus, during the period under review, the provisional government acted as a legitimate subject of political power and exercised state power in conditions of incapacity of the official bodies of public state power. Accordingly, the acts of the provisional government should be considered as formalized means and methods of regulation and management of public relations in the condition of disorganization of the official bodies of state power. So, consequently, the seizure of property from private owners on the basis of the nationalization decrees was an exceptional measure due to the extraordinary situation and the presence of the special need. With the adoption of the Constitutional of 2010 and the implementation of its provisions on the formation of public authorities, the provisional government announced its dissolution by decree number 147. Most of the decrees of the provisional government lost their legal force. Okay. I have some words. So the keynote of the decision was that due to the requirement of the Constitution and the constitutional law, according to which the subject of the inspection of the constitutional control body must be strictly formalized laws and other normative legal acts adopted and enacted in compliance with the established procedures. The issues of the constitutionality of the disputes decrees cannot be resolved by Constitutional Chamber. In essence, the dispute decrees are adopted outside the established procedures, don't have the formal features of regulatory legal acts and cannot be investigated and resolved by legal means in Constitutional Chamber. Moreover, that's why that decrees cannot be subject of consideration by the Court of General Jurisdiction. So the substantive meanings of this obligation is expressed in the creation of the necessary condition in which the subject of any form of ownership will be able to exercise at his own discretion his power to possess, use and dispose of the property, and will also have access to effective remedies if necessary. Above mentioned cases is a justified case of judicial activism of the Constitutional Chamber. Respectively, in such cases, the application of such an approach by the constitutional justice bodies is an objective necessary. Thank you for attention.
Muchas gracias.
The issue was establishing the rule of law.
Los tópicos de la discusión fueron creación de un parlamento para aplicar el derecho mundial.
The particular issues were the creation of a
Creación de un parlamento para aplicar el
global
derecho.
parliament to enforce international law.
Limitaciones de la Corte Internacional y de la Corte Criminal Internacional.
Limitations of the International Court of Justice and International Criminal Court of Justice. We talked about it a little bit. Yeah?
Activismo internacional judicial,
Judicial international activism.
de los cuales nos habló la colega de Argentina y la de
Our colleague from Argentina talked about
de
it.
la Kirguistán. La de Argentina nos dio un
En
caso
Kirguistán,
concreto muy claro.
The Argentine colleague gave us a very specific case, very interesting.
Además de la brillante exposición de la autora ecuatoriana, de la ministra ecuatoriana.
And also we had a brilliant talk by our colleague from Ecuador, from the Supreme Court of Justice from Ecuador.
Y finalmente los dos últimos temas fueron
And finally, the last two issues were
enseñanza y formación en derecho internacional,
teaching and training in international law,
relación entre el derecho internacional y el derecho doméstico,
relationship between international law and domestic law,
del cual maravillosamente hablaste usted.
about which I talked to you.
Y la ponencia más precaria fue la mía, pero fue un alto honor participar de esta jornada.
And the most limited talk, in his opinion, was his, but it was a high honor to participate in this event.
A los niños y jóvenes de este colegio,
To the young people from this college,
les
school,
deseamos, les
we
instamos
wish them
a seguir formándose,
to continue training, learning in this school,
propiciando todos los valores de esta conferencia internacional.
promoting all the values that we talked about in this international conference.
A los colegas de Paraguay, de la Argentina y de toda habla hispana que nos acompañaron hoy también muchas gracias, y a los colegas de otros idiomas también muchas gracias.
He thanks to everyone who took part, especially our colleagues from all over the world. Now we have questions.
Sí, en especial. ¿Qué? ¿Hay preguntas?
10 minutos para preguntas.
10 minutos para preguntas. Bueno, hacemos la apertura para las preguntas entonces. Voy a subirme. Bueno, desde acá, decirle. Okay. Apertura para las preguntas.
Yeah, now we have 10 minutes for you to make questions if you want.
Que levante la mano. Allá, el micrófono. La traductora con el micrófono portátil. ¿Hay un micrófono portátil por ahí?
Translator.
Sí. ¿Hay un micrófono portátil?
Can you come forward? Children who are going to ask questions should come forward.
10 minutos.
We have 10 minutes.
10 minutos para
need
preguntas.
Straight questions, please.
Can we have silence, please?
Sí. Vos sos la traductora. Ahí está, sí.
Children who have questions can line up out here.
Bueno, espectacular.
Hello.
Muy bien.
Good afternoon, sir. Sir, as Honorable Judge of Paraguay had just told about the Human Rights Treaty, I want to ask, how can a child who is a victim of a child labor, and how does the woman who is a victim of a human trafficking, as he is treated as a prostitute, can reach the court you have quoted? As in a domestic courts, they have a strong link. The perpetrators have a strong link. They can do a crime and they can escape in the domestic rules. Yes.
Muy bien, traducción por favor, porque hay gente del auditorio que no hablamos inglés y queremos saber qué es lo que preguntó el muchacho.
Sí, la pregunta es la pregunta es dirigida al representativo de Paraguay, y la pregunta es si hay un niño que está involucrado en trabajo manual de los niños, child labor, o hay una mujer que es una prostituta si los dos van a pedir la justicia en el corte doméstico y los que les violan también tienen más poder de ellos, ¿cómo el corte puede asegurar que los dos que son violados pueden tener la justicia?
Well, there's a very sad reality. Unfortunately, it's very frequent. Child trafficking, women trafficking, and in fact, well, in Latin America, we have a rule that you have to go to local courts first. And once your request is denied by local court, then you can go to international courts. And if your request is denied, that doesn't mean that you cannot reach the international court. Now, it is very difficult for a person, like you said, for a child or for a woman who had been treated like a prostitute. It's very difficult to reach those institutions. But every country has the responsibility of making these things easy for them. And there are many countries, like Argentina, for example, they have many agencies that help this kind of people to take their cases to the international courts. Some other countries, like Paraguay, they find it very difficult, this kind of people. But there are experiences, real experiences. For example, the one I said, the one I talked about, Aboriginal people. Those are very vulnerable people in my country, but they could reach international courts. So it is really possible. It is difficult. I'm not going to deny that. But there are resources, and every country has the responsibility to make it easy. Otherwise, they also are accountable before the international community for not having make things easy for this kind of people to reach international courts.
Sir, do you think any international body should be made to help them, to assist them to reach these courts? Do you think?
Yes. Actually, in Latin American context, we have two stages in the international procedure. The first one is before the commission. That is not a tribunal. There is not a court. It's an institution that helps this kind of people and tries to get to an arrangement with the country involved so that the case will not go to the court. And this is a very efficient filter because the vast majority of cases are settled in this stage. So there are, before this judicial stage, there are other stages that can be used so that the victims can have a reparation, a compensation. And this normally work better than the court itself.
Thank you very much. Vamos a pasarle al otro muchacho para que pregunte también. ¿El sistema es una sola pregunta por persona, como es, señora traductora? Porque generalmente es una sola pregunta por persona.
Okay, so I just want to announce that one person can ask just one question.
Sí, para dinamizar la cuestión. Ahora, adelante, joven.
The Israeli West Bank separation barrier is a wall in West Bank that separates the West Bank from the rest of Israel. According to the International Court of Justice, the barrier is completely illegal. Despite this, the construction has not stopped. According to you, what can the international community do to make sure that the decisions of the International Court are not violated?
To whom are you directing this question?
It's open to the one.
Okay, es la pregunta dirigido a todos y a la mesa completa y la pregunta es cómo ustedes saben que el asunto de West Bank en Israel, el área de West Bank es ilegal según el Corte Internacional de Ley. Pero también la construcción en aquella área consigue. Por eso, él pregunta a toda la mesa cómo ustedes piensan que el Corte Internacional puede jugar un papel a dar justicia.
Correcto. No sé quién de las compañeras quiere responder en primer lugar. La de Ecuador, la de Argentina, o si no, respondo yo. Bueno. Todo acto que atente contra la paz mundial, la dignidad de los pueblos, la soberanía y la integración de nuestros habitantes de este país gigantesco llamado Tierra, no puede contar con la aprobación de nadie.
Okay, so anything which threatens global peace, the power of the common people, the sovereignty and dignity of common people cannot and should not be attacked by any particular country.
En consecuencia,